Mr.
No.
West, don't interrupt me. It makes a garbled record and it's no good for anything.
Sorry.
I need you to respond to counsel's argument that he doesn't have enough facts to defend the lawsuit.
Okay.
It's just the way the process works. The fact that they might know some of those things they're telling you to put in your complaint from outside sources doesn't change that. Okay, hold on a minute. I don't want to talk about the motion.
Okay.
All right, are we ready on West versus Gem Seal and Rutger?
Yes, we are, Your Honor.
All right, Mr. West, you are muted, sir.
Can you hear me now?
I can, thank you.
Yes, sir.
Counsel, your appearance, please.
Good morning, Your Honor. Michael Hanchett on behalf of the defendants.
All right, you're representing defendant 1 and 2, correct, counsel, just to be clear?
Yes, correct, Judge.
Okay, thank you. And what's scheduled today?
Your Honor, it's defendant's motion for a more definite statement.
And a motion for declaratory order.
I'm sorry, say again, Mr. West?
We have a motion up for declaratory order. Under the Michigan Consumer Protection Act, we're entitled to declaratory order.
That's something new you filed?
Yeah, I filed that through filing on May 1st.
I don't know if I've seen that. Let's see if we can find it on the computer. All right, I got your response to the defendant's motion. All right, well, let's talk. I've got Malachi here trying to find that declaratory order motion. In the meantime, let's talk about defense motion for a more definitive statement. Counsel, go ahead.
I thank you, Your Honor. I'll be very brief, Judge. So plaintiff has filed a new complaint on February 28th of 2024. It's a 6-page complaint. It fails to set forth any facts to support these claims against any of the defendants. It doesn't actually allege any facts specifically against Mr. Rutgers. We've provided Mr. West with the correct entity to sue multiple times, and he continues to file against the wrong entity. He fails to show also why he has standing to sue in this case. He was just the person that purchased the product. He wasn't the individual that the property was actually damaged. So without the additional facts, we cannot properly respond to Mr. West's complaint. So we'd ask the court to require Mr. West to file a more definite statement.
Can you go ahead and respond to that motion? West response. Go ahead, Mr. West. We're going to pull up your response to that, but go ahead.
Okay, my response is, first off, the complaint clearly lists 2 counts. Count 1, product liability. Count 2, property damage. And that's the second plaintiff who's been trying to get in on Zoom and it's not been allowed. And
okay, hold on a minute. You say there's a second plaintiff, but I'm looking at the case heading. Oh, okay. Hey, Heather.
Yes, Judge.
Yeah, Mr. Sanku is listed in this new paperwork.
All right, yeah,
Go ahead.
On our docket, it doesn't show up, but he is here in the meeting, Mr. West. He was never denied access into the meeting.
well, he's
I am in now.
okay.
Yeah,
Yes.
we just had to figure out who he was, Mr. West.
Okay, that's fine.
Okay.
So on with the issues that counsel has presented. The plaintiffs are bringing this complaint to the court under the Michigan Consumers Protection Act 445.901. And it's pretty extensive complaint. Protection Act. That Protection Act allows for the plaintiffs to bring the declaratory motion order when.
Okay, hold on a minute. I don't want to talk about the motion.
Okay, let me go back. I'm sorry, I got off.
Mr. West, don't interrupt me. It makes a garbled record and it's no good for anything.
Sorry.
I need you to respond to counsel's argument that he doesn't have enough facts to defend the lawsuit. That's his argument today.
Yeah, any issue, number one, any issue that he would suggest is confusing to him, he could simply say, doesn't provide enough information to provide a response in his answer. His whole, this has been going on for a year now, and their whole issue is to discombobulate the consumer. And that brings us to, let me stay on the numbering issue. So in the complaint heading, it says count 1, product liability, count 2, property damage. And then if you go to page 4, it clearly lists product liability, count 1. And then it also even goes.
Okay, Mr. West, hold on. I'm sorry.
Go ahead.
Counsel's argument is not that he doesn't understand what theory you're suing under. His argument was that you don't provide the facts that build a case. He understands product liability is one of your claims.
Well, he's saying that I did not provide numbering in the complaint. And he cites, okay. I'm just saying we provide numbering in the complaint. We list every line numbered, and then we list each complaint number.
This is defendant's motion, defendant's response to plaintiff's response. Can you find plaintiff's response? Go ahead.
So we provided very specific and concise. It's negligence, and they sold us bad product. This is not a medical malpractice case. They sold us bad product, simple as that. And they destroyed the product. They sold the product as new, but when they put the product in the container, it became altered, and that caused the damages. So again, they're violating the Michigan Consumer Protection Act by selling the product as new when in fact it's been altered.
Any other response?
The negligence of installing the product into a unmarked container is a violation of the Michigan Consumer Protection Act.
Which is not what we're arguing right now.
We're arguing the specifics.
No, we're arguing defense motion for a more definitive statement.
That's specifics in my world. And I'm saying that it was negligent by the party installing the product in a container that was not new. That's
all right,
violating.
Mr. Hanchett.
Yes, thank you, Judge.
Anything else, Mr. West? At this time on that motion?
Go ahead.
Go ahead, Mr. Hanchett. Any response?
Just very briefly, Your Honor. Obviously, the numbering that we're referencing is that he never numbered the specific allegations in his complaint so that we can respond properly to that as required by the court rules. What I've heard Mr. West say is that we sold him a bad product, but he hasn't told us when, where, or what we sold him. So that's what we're looking for in our more definite statement. And then also, I'm not hearing a response as to why the wrong defendant has been sued.
Mr. West?
I addressed both of them. Judge, this case was brought in the plaintiff number 2 jurisdiction, and the judge required it to be brought in your jurisdiction because that's where the product was sold. The product was not sold by PMGS MMI LLC. They had nothing to do with it. In fact, the plaintiff has provided this court with a U.S. Department of Transportation Snapchat clearly showing that PMGS MMI LLC is a trucking firm out of Auburn Hills. And again, this is the process that they have 5 different businesses running out of the Van Born Road address. And that is a violation of the Michigan Consumer Protection Act. Clearly, they are presenting a confusing business practice to the consumer. The defense counsel is acknowledging the confusion by saying we're suing the wrong individual. If the court would look at the letter that Mr. Lois, Chief Operating Officer, provided to the First Circuit District Court jurisdiction, it clearly indicates that, and he just said that he doesn't even know when the product was bought. And here we're looking at a letter from the Chief Operating Officer to the First Court, a district court out of Ann Arbor, and they're saying the product was purchased on May 17th. I can't get any more specific than that. They acknowledge.
Stop.
Yes.
But it's not in your complaint. The fact that they might have information about when things were sold from an outside source does not change the fact that it's got to be in your complaint.
Okay, well,
Mr. West,
Yes.
you have read and drafted enough complaints and pleadings to know what this is about. You need to lay out the facts that support your legal arguments so that then the defendant can respond to those facts.
Okay.
It's just the way the process works. The fact that they might know some of those things they're telling you to put in your complaint from outside sources doesn't change that.
Okay.
All you're doing is you're giving them another reason to file a motion for summary disposition and say, Judge, there's no case here because there's no facts here.
Okay.
File a proper complaint, put all the facts that support your allegations in the complaint, then they can file an answer and we're off and running.
Okay.
Now, so that motion from the defense is granted. Now let's get into your declaratory motion. Let's get into the motion that you filed.
Okay.
Go ahead, Mr. West.
Okay, I filed the motion for declaratory judgment because I respectfully submit to the court that the facts are simple enough to where we have already addressed the issue as to whether or not the material was sold by the defendant and it was defective. And the fact that it was defective should afford the plaintiffs the opportunity, or should afford the plaintiffs the right to have a declaratory judgment regarding the product, whether they knew the date or not.
All right, counsel, your response to that motion, please.
Yes, Your Honor, and thank you. I'm just seeing this now for the first time as well, but it looks like what Mr. West is claiming here in this motion is that the defense has failed to properly answer the complaint. That's obviously not true. We filed a motion for a more definite statement in lieu of an answer. As for the reasons stated in our motion for more definite statement, we obviously don't have the facts in front of us as pled by plaintiff for us to reach even an answer, let alone a declaratory relief as he's requesting here. So we'd ask the court to deny this motion.
Mr. West, I'm going to deny it at this time because I think it's premature. Let's get the answer in, and then if you think that you still have a good motion, refile it.
Yes, sir.
Understood?
Yes, sir.
All right. Anything else, fellas?
Do a better job next time, Judge.
Nothing. Thank you for your time, Judge.
All right. Thank you, gentlemen. Enjoy your day.
You
Okay,
too.
bye.
All right. I'm sorry. Was that plaintiff's motion?
Defendants, Your Honor.
Yes.
Defendant's motion. All
Correct.
right.
Or I'm
Go
sorry.
ahead,
defendant's
counsel. Hit the highlights of your motion.
Thank you, Your Honor, and I'll be brief to the best of my ability. As this court is well aware that this matter arises out of a motor vehicle accident on June 27, 2020. Importantly, Your Honor, this case was not filed until November 16, 2023. The partial MSD before this respective honor pertains to the 1 year back rule, otherwise known as MCO 500-3145. Now, plaintiff's own ledger does demonstrate that defendant paid plaintiff for all but the recent charges, and as such, plaintiff's only seeking the balance between the amount charged and the amount paid, Your Honor. Pursuant to the 1-year back rule, however, the claimant may not recover benefits for any portion of loss incurred more than 1 year before the date on which the action was commenced. As such, plaintiff would be prohibited under the plain understanding of that rule from recovering benefits incurred prior to November 16, 2022. Now, the no-fault amendment back in 2019 did apply essentially a judicial tolling to that 1-year back rule, stating that the 1-year period of limitation is tolled from the date of a specific claim for payment of benefits until the date the insurer formally denies the claim. So originally, we're going to argue that the 1-year back rule does not apply, but in the alternative, if it does, then obviously the benefit would be precluded that predate the October 15, 2022 date rather than November 16, 2022. Now, the most recent barred claim is represented on plaintiff's balance sheet as October 16 of 2022. Plaintiff billed defendant on October 18. Defendant issued its formal denial on November 11th of 2022, resulting in a tolling period of 24 days. Since the most recent date of service of October 15, 2022 was 32 days outside that limitation period, it remains time barred despite that respective tolling that was brought about the no-fault amendment reform, Your Honor. But again, even if this court is persuaded that the tolling application does in fact apply to plaintiff's respective claim, the reasonable diligence is a precondition to invoking the tolling set forth in the preceding sentence. In this respective case, plaintiff waited 19 months after its respective formal denial that was received to file its respective suit, and no other apparent action was taken. By waiting the 19 months, it did not act with reasonable diligence to essentially trigger, Your Honor, that respective tolling that is allegedly applicable, if it's applicable at all. And so we're arguing that the dates of services that obviously predate the 1-year back rule from the filing of this case, November 16, 2022, should be dismissed if, again, this court respectfully perceives that the tolling application still does apply, even though plaintiff waited 19 months to file its respective actions. We're still arguing, though, then dates of services predating October 16th, 2022 would be barred under that tolling of the 1-year back rule, Your Honor.
Thank you. Or preferred response?
Yes, Judge. Your Honor, I do apologize. The internet problems inside, so I came outside. It's kind of simple, Judge. Counsel made that a lot more complicated than it needs to be. Does the court have a hard copy of my motion in front of it?
I've got one on base. I've got one on the screen.
Okay, that's fine. So Exhibit 1 to my motion, Judge, outlines, and in our motion does too, outlines our data services and what we're billing.
Counsel, hold on. You said Exhibit 1 to your motion. You mean Exhibit 1 to your response?
Exhibit 1 to our response, correct. Sorry, Judge.
That's fine. I just want to be clear. We're looking for that exhibit now.
Outlines the data services. When you get there, let me know, Judge.
Got it.
Okay. And Exhibit 1, you can see every time we invoice, our dates that we're at going back to are an invoice dated 3/16/22. That's where we're going back to. That's the date. And as you can see, which is also important here to note, judges, it's not that the plaintiff or the defendant doesn't pay our bills. The defendant chooses how much the defendant's going to pay based on what the defendant decides to pay. That's for trial. But nonetheless, they admit that the patient was injured. I mean, Judge, I think this patient's been injured for over 10 or 15 years. Serious brain injury. My client only handles brain injuries. Important to note, came to our office back in March 16, 22 to get driving transportation from us. And we invoice. And then on the EOBs, when the provider, when we send them into the insurance company, they decide to pay whatever rate they want instead of Progressive paying what they're billed. If you go to Exhibit 2 is just a case, which is right on point, which says that EEOBs are not denials. And you need a formal denial. Just like the court's aware in every other insurance world, it's not 1 year back from the date of the loss. It's 1 year back from the date of the denial, which is important. Exhibit
I thought defense counsel said that there was a denial, formal denial.
No, there was not. Exhibit.
Okay.
All that defense counsel did was deny an EOB. And In response to that, my client, defense counsel says my client wasn't diligent. I would like my client to go, or judge, just now go to exhibit 4. We can skip exhibit 3 because exhibit 4 is as clear as day could be.
All right, give me a minute to try to find it. All right, I'm on exhibit 4.
The court goes to the bottom of page 2 of 3. The court's going to see an email dated February 3rd of 23. From Jennifer Parker to my client. Starting, "Good afternoon, Rachel." And they're talking about for the 222 to the 228 billing, it appears that payment was stopped because it was mailed to the wrong address. But I was never reissued any place or quote to reissue for there will be no whatever. The second line is the most important. It's, "I am still working on the rates." Prior to that, there's an email before where my client's talking to them about, "Hey, you're not paying us the rates that you're supposed to be paying us." If the court goes to page 1 of 3 on exhibit 4, you'll see an email dated February 6th, 2023, where finally Progressive gets back and it says, "Good afternoon. I have discussed this and I am not going to be able to increase the rate." And they discuss why they're not willing to increase the rates. So the actual, my clients, and this is a form denial. This is,
Say that again, counsel. Say that again.
So what I'm saying, Judge, is as early according to law, the case we attach, this is not a
I'm
formal
having trouble
denial.
with your audio, counsel. Your audio cuts out.
All right. Having trouble internet problems. I'm sorry, Judge. I had 2 other courts, so I had to be mobile today. Can you hear me better?
For the time being, yes.
Okay. Exhibit 4, email dated 6/7. Progressive says, "I finally heard back and I could not change the rates." Did you hear that?
Yeah, I'm looking at the February 6th email where they explain why they're not increasing the rates. I got that.
Okay. So we then file in November of 20. We file in November of 22. So we had until that February denial allows us to go back February, 1 year back from
All right.
February.
I can't do this. I can't do this, guys. I can't do this.
I'm so
You
sorry.
guys can come in and argue this live. You can argue this live. I'm having enough trouble trying to deal with paperwork that's not paperwork, and I can't do it if I can't hear what's being said. We'll schedule it live. We'll schedule it live.
I'm sorry. Thank you. It was another court. Sorry. Internet problem.
I get it. It's not your fault that the powers that be have pushed this on us. Heather, give me a date for these guys to come in.
I never have this problem.
All right. Either we have next Thursday again in the afternoon, or we have Monday, Tuesday, July 8th or 9th.
Thursday in the afternoon is fine for us, too.
June 27th.
Yes.
What was the July date, just so I can consider them along with the June 27th date?
July 8th or 9th, Monday or Tuesday.
Your Honor, could we do the July 8th? Is that okay?
If it's all right with both of you, I just need to get all 3 calendars together.
That's fine, Judge.
In the morning or
What time,
afternoon?
Heather?
I have 10 a.m. or 1:30. Or 1
1:30.
o'clock.
1 o'clock.
1:30,
o'clock?
agreed?
Yes.
1 o'clock? Where are we at?
I'm fine with
Either
that. We could do 1, Your Honor. 1 o'clock is fine.
All right. Thank you, gentlemen.
Will we be receiving notice or is this our notice, Your Honor?
Absolutely. We'll send you notice.
Thank you so much, Your Honor.
Enjoy your day.
Have a better one. Thank you.
A courtroom hearing took an unexpected turn when a defendant who had already pleaded guilty suddenly suggested he didn't commit the crimes. The judge immediately stopped the proceedings and began questioning him. Confused by the change in story, the judge reminded him that guilty pleas are based on facts admitted under oath. Then came the powerful moment that silenced the courtroom. You don't come in and plead to things if they're not true. The judge made it clear that the justice system cannot accept guilty pleas from people claiming innocence afterward. Sentencing was postponed, and the defendant was ordered to speak with his attorney again.